So good afternoon and Happy New Year. It is my pleasure to welcome you back for this second term of our CELS seminar in my capacity of co-executive director of CELS. Our guest speaker today is Zoltan Fleck. Professor Zoltan Fleck is Professor of Law and Sociology at the Eotvos Lorand University at Budapest. And Professor Fleck is very well known for his work on the Hungarian legal institutions and in particular the Hungarian judiciary. And Zoltan has been writing for many years on the rule of law and judicial independence in Hungary, mostly from a sociological perspective. I was privileged to meet him for the first time in 2010 in Ukraine, in Kiev, to discuss judicial independence in Eastern Europe, South Caucasus and Central Asia. And so I'm delighted to present him here today. Zoltan has been a public and critical observer of the situation in Hungary for the last few years. Let me remind you that in September 2018, the European Parliament demanded that the Council act to prevent the Hungarian authorities from reaching the EU's founding values. And MEPs were concerned about the independence of the judiciary, the functioning of the constitutional and the electoral system, freedom of expression, corruption, the rights of the minorities, and the situation of migrants and refugees. They asked the Council of the EU to examine the situation in Hungary with a view to determine whether, under Article 7.1 of the TEU, the existence of a clear risk of a serious breach of the values laid out in Article 2 existed, and with the aim of addressing appropriate recommendations to Hungarian authorities in this respect. In a resolution adopted last week on 15th of January, the MEPs noted the reports and statement by the European Commission, the UN, the OSCE, and the Council of Europe, which indicates that the situation in both Poland and Hungary has deteriorated since the triggering of Article 7.1 of the TEU. And the European Parliament calls for better mechanisms to ensure the protection of the rule of law and the values stipulated in Article 2 of the TEU. So Zoltan will discuss today the sources of authoritarianism in Hungary to help us understand the reasons behind the dismantling of the rule of law in Hungary, with the judiciary as an illustration. The floor is yours.
Thank you very much for your introduction, and it was really very informative about my present lecture, and thank you also for invitation for this lecture, and I'm really very glad to be here in the not ancient building, but the ancient university. Firstly, it's really not about the legal processes and legal details of the situation, but about the historical and sociological explanatory trials to grasp the very essence of the causes. Despite the fact that I'm not sure that every event have distinct causes, so it's not a world where everything can be understood by giving causal interpretations. But however, so I must explain the title. That is very thoughtful in a sense that it's really about history, institutions, and ideas. So the core concept, of course, the rule of law. But I don't want to speak a lot about the idea of rule of law and the theory of rule of law, but I get it as a core value of the modern state systems. But I'm very sure that if you want to understand the present situation in a post-communist country, as Poland or Hungary, we must dig into details of the recent and far past. So the history will teach us about the real essence of the progresses in our time. theoretically, the institutions are very important, and I will use the concepts from historical institutionalism, which are very good concepts to grasp the essence. And ideas are also important. So my central thesis here that ideological, conceptual, theoretical developments are very important in a country for the development of rule of law institutions. So theories matter a lot in a modern system. By the introduction, just two terrible quotations from the Prime Minister, who in a press conference in January said that the people in Gyöngyöspata is a very poor little village in the northeast part of Hungary, and there's a very bad situation of gypsy students who are learning in segregated classes. In the segregating cases, they won several cases the last years, and the Prime Minister said that it's a nonsense. They will not pay a penny for as a compensation against the verdicts of the Hungarian courts. And it's really a new phenomenon in Hungary because from 2010 it is a normal situation that there's a huge lip service of denying the values of rule of law and democracy, but the formal institutions are working, verdicts are accepted by the political elite, even the government. So this is the first time where not only the legal modification of the system is on the table, but a pure and simple denial of the most important aspect of the rule of law, the prestige and working of the judicial sentences. The second quotation is from the Vice President of the Hungarian Supreme Court, the Curia, who said in a law journal recently that the key figure in the judicial work is the public prosecutor, which is also a terrible sentence from the perspective of the autonomy of the judiciary and autonomy of the judicial argumentation. So I'm not speaking about directly on the legal culture, but just look at these two pictures. These new buildings of the Hungarian high courts, which symbolize something, I think. It's the closeness. It's like a bastion, like a building who must defend people inside. So it's not an open administrative building. It's really a symbol of the Hungarian closeness of the judicial mind. So, against this culture, there's a new phenomenon. It's the Warsaw Street a couple of days before, where the Polish judges and some judges from Europe, even Hungarian judges, demonstrated against the Polish governmental acts on judicial disciplinary rules. So there are two cultures in Europe, and in these post-communist countries, there is a closed authoritarian remnant of the past and a new epoch, a new beginning, where we don't know the exact outputs, but we have some hopes that something is changing. So this is about a new rule of law revolution or a rule of law beginning. So Polish judiciary has reached, I think, a peak of the possible judicial resistance when Justitia, an independent, apolitical, and self-governing association of judges, organized an international demonstration against the new disciplinary rules of the government of Poland. The members of the Hungarian Judicial Council, I know some members of the Hungarian Judicial Council, and other judges are not so much, so it's about 10, are still marching on the streets of Warsaw, but some open criticism against abusing judicial independence at home in Hungary appeared in Hungary. So there's some signs of resistance. So the bitter fights for judicial independence and autonomy in Hungary and Poland are well documented, and nobody can seriously think of Hungary as a rule of law system. So it's I have serious disputes with social scientists and mostly lawyers on the nature of the present system and the regime. But there is a common point that the rule of law is not the proper characteristic of the Hungarian situation now. So Hungarian Prime Minister and leading figures of the governing party continuously discredit judiciary and question the rationale of judicial interpretation. But it is not only populist lip service. After the long story of curtailing judicial autonomy by administrative regulations, recently Parliament issued an act which made the ministerial reasoning of the law compulsory for judges. But Hungary is not a precedent, not a common law system. It's a traditional continental system. But it's a new phenomenon that an act made legally compulsory for judges in the interpretation of the law, that the ministerial reasoning of the law is the starting point for the judge. It's really a new system. Another legislative act tied down the hands of judges by a new obligation of giving a written justification if a legal interpretation differs from the decisions of the Curia. So it's the second point which can limit the scope of the judges. One is to the political rationale of the law. The second is the higher level of judiciary, which is quite normal that sociologically that the judges are following the interpretation of the Curia, but not by the legal acts. It's not a compulsory system. It's really another breach of the traditional judicial autonomy system. Meanwhile, the Judicial Council, as the main bastion of the independence, revived and started to fight for autonomy. The upshot is still uncertain, but it is the first time in Hungarian history when judiciary resists collectively, or at least by a collective body. It is not hyperbolic to evaluate this as a cultural turning point. I try to unfold in this lecture why. Something about the so-called new authoritarianism, which is very different than the old style authoritarian system. We all know that law, this is the only point where I have some jurisprudential concept. We all know that law is a Janus face entity. The inner authoritarian seed in the law is based on the logic of command and obeying, and the fact that law is the dominant tool of any power in modern societies and the major instrument of legitimacy, thanks to Max Weber. This makes law, continental hierarchical structure especially, open for authoritarian capturing. using legal tools for authoritarian aims does not count extreme. It's quite normal in the European history. And of course, judges may participate in authoritarian uses of law by unquestioning obedience to rule and other authorities, by using stereotypical reasoning, by upholding the status quo and hypostatizing power relationships, and by taking a punishing attitude towards disobedience. So it's a normal function of the judiciary system. Authoritarianism goes global now, but this most of the time and most places differs from old school dictatorships. Not just because their origins, which look like a slow deterioration instead of coup d'etat, but because of their hypocrite characteristic. It's the lying, the continuous lying of politicians and lawyers about the nature of the system, the nature of the regime. As dictators learned the election play, new authoritarians speak the language of the rule of law and keep lying about the nature of the regime. The most important feature, the dominant characteristic of the new authoritarianism, is its democratic wardrobe. Democratic institutions formally function the same way in these regimes that they do in democracies. The former rule of law institutions and mechanisms strengthen stability by ensuring legitimacy. It protects against critics. The institutions serve as information sources and so on and so on. There are some functions. Of course, former rule of law, the so-called the great rule of law cheating, the language of constitutionalism makes any revolt against the regime illusory and makes the process of reconstruction extremely complicated. So what is the next period is a very complicated situation, but fighting against a former rule of law, formal institutionalized system with the help of the values of the rule of law. So the next couple of years will demonstrate some very harsh battles and disputes about the very nature of the rule of law. Whether is it a formal institutional system or a value-laden system of governing. In East European legal tradition, this fake constitutionalism, the Potemkin democracy, has its own place and strong antecedents, which confirms the need of historical analysis instead of pure political evaluation. Hungarian political history is full of fake elements, as Hungarians are very good in accepting these phrases. Kingdom without king, admiral without sea, people's democracy without democracy, elections without options, revolution without revolutionaries, constitutional question without constitutionalism. It's a quite big tradition in the Hungarian sea. Sometimes some lies, especially myths, breed creative illusions, even imaginations. But in an authoritarian setting, mostly serve only authoritarian aims. To be fair, hollowing out of democracy is not a post-communist question. Hollowing out democracy and rule of law is quite common and quite present in Western European states also. So, but this is the point which I'll not concentrate on here. Some words about the historical institutionalism as a conceptual tool. The recent histories of Central European states are without doubt interesting from the perspective of theorizing temporality of social transformations. Constitutional design, democracy building, institutionalizing market economy, and stabilizing rule of law have different time frames. Thus, temporal context matters. Any analysis must move back and forth among at least three temporalities: structural or historical longue durée, the institutional, and interactional. So that there are two or three different time perspectives from this grasping of the problem. The contingent events evoked above cause tremendous puzzles concerning the political, cultural, historical, and other kind of causes. One of the signs of huge vagueness is the extreme conceptual variability by which these regimes are depicted in the social scientific literature and mostly in the political literature. Most of the conceptual attempts are informative on the very essence of the present state of the art in post-communist societies. From, these phrases, constitutional counter-revolution, or anti-constitutional populist backslidings. This is a very good concept. But the most usable concept, or the most widely used concept is hybridity. And the hybridity as the mostly used term in itself mirrors the lack of the conceptual maturity and a temporal mismatch. So it's really we don't know exactly what it is. It's a hybrid system. So it's really I think it's not good enough to understand the things. In the attempts of mapping the divergent conceptual development, it is evident that there are no clear boundaries, but a sort of family resemblance. Incremental democracy dismantling, as an umbrella term for conceptualizing the process. Autocratic legalism is for grasping the dominant mechanism and authoritarian hybrid regime as a structural outcome. It is the conceptual frame of the present social science literature on the Central European hybrid regimes. From the perspective of legal sciences, the central element in this conceptual framework is a distorted legalism, which shed light on a more general feature of the modern law, its in its face or dual nature. So it's a very important concept here, the duality of the modern law. After the breakdown of the illusion of the swift and smooth success of the post-communist revolutions, a new attempt to conceptualize and analyze the processes and causes should take into consideration the temporal processes, historical sequences, unintended consequences, path dependencies. As Paul Pearson argues, institutional development, in turn, cannot be adequately treated without attending to issues incorporating an extended time frame, including the role of time horizons, unintended consequences, learning and competitive selection processes, and path dependence. It is the very essence of the historical institutions in this question. So, social political institutional changes in Eastern Europe are contrary to the prevailing view of the political sciences and even the everyday language, not transitions from one state, communist dictatorship, to another, democracy, but peculiar rearrangements, reconfigurations, recombinations of logics, traditions, institutional settings. So it's a mixture of old and new elements of the system. Brand new constitutional institutions of rule of law and democracy are not really new, as legal system cannot be written on a blank slate. Rather, they are institutions which embody shared cultural understandings and behavioral patterns over time. From this perspective of historical institutionalism, stability and changes seem much more complex. The proper way of formulating questions is this. What particular kinds of external events and processes are likely to produce openings that drive path-dependent institutional evolution, and what kinds of events, processes have the capacity to undermine the institutional legacy? So, for short anticipation of the topic of the dynamics of the judicial system, these questions completely reformulate the analysis. So, in the following sentences, I try to find the evaluation of this or uses of this conceptual framework. The who say political change in Hungary, the constitutional peaceful transition to democracy, the institutionalization of the rule of law and rights, including declaring judicial independence and building safeguards into the constitution, could not challenge the long, stable heritage of judicial self-restraint, passivity, and subordination. Despite the illusions of the self-enforcing autonomy, judiciary did not show activity in reformulation of their professional values and ideology. So the professional values, the judiciary remained the same after the institutional transformation. However, the last justice minister before the first democratic election, the late legal scholar Kálmán Kulcsár, has modified the legal regulation to minimize the effects of the executive to the judicial branch without a new administrative model. What is interesting, the new model making had to wait years. The Judicial Council was established only in 1997. Meantime, the strong men of third branch, the middle-level administrators of the court system, the county court presidents, who were nominated by the minister to their posts, and under the communist rule, the party consensus was needed for the nomination, took the power into their hands. So there is a very strong continuity of these guys. So there was a communist past where the county court presidents are the core figures in ideological political judgeship. And after the transformation, they could get the posts for a continuity of the power structure. So these guys detected the draining of the ministerial control and filled the vacuum by informal coordination. The cooperation of these strong men expanded the lawmaking processes of the new Act on Judicial Administration also. And even after the Judicial Council stepped on the scene, they succeeded to preserve their influence. So this is a very interesting point of the Hungarian judicial culture. So there is a strong position under the communist rule. They kept the position sociologically after the transition, and even a very huge administrative reform could not eliminate this power. In 2011, as an element of the building a new authoritarian state, this new conservative government, now the two-thirds majority abandoned the strong judicial council administration, which functioned with an uncontrolled administrative distortion thanks to the continuity of the power of court presidents. So what the Fidesz government did, it's really historically a very well argued step to eliminate this old non-effective system. This centralization of politicization of the judicial administration at the same time radically rewrote the inner structure of the judiciary by eliminating the long tradition of autonomous superpower of the county court presidents. However, the price is enormous. The central political intents can prevail without resistance because the president of the judicial office, who is elected by the majority of the parliament, can nominate the county court presidents. So the county court presidents are again very important figures in the system, but they are not autonomous judicial figures, but nominated by the president of the office, who is elected by the two-thirds majority in parliament. So it's a political channel which is quite new in the system, but not completely new concerning the pre-transition period. What has changed now? From the perspective of sitting judges, the presidents are still the strong figures. But in reality, this strength differs in character from the previous period, because it is directly connected to central political intents by the channel of the president of the office. The long tradition of political influence through judicial leaders is unbroken through system changes and legal reforms. The source of interest has changed immediately before the political transition, when central political influence became illegitimate and gave its place to the oligarchic self-interest. And finally, central political influence found its new institutional form after 2010. So there is a circulation of power structures behind the institutional surface. This mixture of continuity and change cannot be grasped by depicting only the legal institutional changes. It really needs the perspective of historical institutionalism. Even so, this low-level autonomy and political influence remained the central characteristic of the judiciary in the long run. What is completely new phenomenon with non-historical roots is the revival of the judicial mind. Some guys in the judicial council who are very active now against this bad tradition. So this is the system. And for the next two points is about the short history of the Hungarian state, because we need some more deep knowledge on the Hungarian and Poland, on Polish history, because we know from, for example, Thomas Erdmann, that some states in Europe had developed in constitutionalist direction and institutionalized the limits of power, and others became absolutist at the same time. But he argued that formative periods and the subsequent dynamism of state building have left a lasting mark on the power structure of the Leviathan. This book is excellent. This Thomas Erdmann book, the title is The Birth of the Leviathan, Building States and Regimes in Medieval and Early Modern Europe, in Cambridge University Press. What is relevant for us here is his deviation from the traditional dichotomous historical model of absolutism and parliamentarism. In Hungary and Poland, a patrimonial constitutional political regime emerged without modern or proto-modern state bureaucracies. And what is the state administration? And it is the important point. The process of late state building and its operation remained in the hands of the non-professional noble strata, local land-owning elite. Patrimonial constitutionalism could limit all the centralization by the ethnically different emperor. That was the very essence of the Hungarian history. Noble fighting against the Habsburg centralization, the Habsburg modernizing centralization. The lack of strong central power, the constant noble resistance, preserved these countries in a patrimonial backwardness. However, not only the delicate balance between strong central power and local participation was missing structurally, and consequently the efficiency of state regulation, but the possibility of political integration by public administration, which is a very interesting concept. Contrary to the usual Weberian evaluation, there's a very good German article in the Public Administration Review. Wolfgang Seibel demonstrated that organizational bodies in the public realm might serve as mobilizing force, might have identity-forming capacity, and might create symbolic meanings and integration. So it's not a Weberian evaluation of the state bureaucracy as a rational institutional component of the modern state, but this German author said that a modern bureaucracy can serve the social integration, and without it, the very basic element of the rule of law system will collapse. And this is the integrated society. His example is Germany, of course, before the period of modern parties and parliament, in the period of Lorand von Stein, Otto Hinze, and Rudolf Smann, three very excellent German legal theorists, who as legal scholars, public state lawyers, focused on the mediating, social integrating functions of the public administration, state bureaucracy. Even against the parliament, the highly qualified, integrative, professional apparatus seemed much more trustworthy, stable, and socially acceptable. The spirit of the civil service is closely connected to the popular common sense, conventional wisdom, even national identity. And social integration, furthermore, it was elastic enough to be, so this concept of public administration was elastic enough to be able to imply the conservative justification of the strong state, as well as the liberal defense of the public interest against the abuse of power. For this double function, or elementary resilience, the ideas and theories of Rechtsstaat were necessary, of course. Contrary to German state building, the Hungarian ancient state and political elite, in a patrimonial structure, kept the autocratic principle alive without any limits, and functioned with the anachronistic fiction of Holy Crown. The Holy Crown was the only constitutional fiction of the Hungarian state. State authorities regularly issued decrees at their discretion in different matters concerning rights, and courts applied these governmental ministerial norms. The lately codified independence of judiciary did not change this practice either. Under this legal system, based on the autocratic principle, individual rights were, in a sense, concessions from the state, made either through independent executive action or by legislation. So it's the autocratic tradition of the Hungarian state. In Germany and Austria, the autocratic state was balanced, or at least compensated, by the Rechtsstaat, the rule of law. Opposing social forces could refer to the higher norm of limited executive power and its social duty of social integration. In Hungary, instead of integrative bureaucracy, social and political elite have stubbornly nurtured the mythos of historical constitutionalism based on the sacred qualities of the crown. And in brackets, I must say that Montesquieu was very bad in this story, because he had very good connections to Hungarian nobility at that time. And the fighting against the Habsburg Emperor, the Hungarian nobility got a letter from Montesquieu who said that it is the constitutional fight. But it was not. It was not a constitutional thinking in a Montesquieuan sense, but Montesquieu just made a mistake of saying that the Hungarian nobility are fighting against the Habsburg Emperor, and this fight is the constitutional limit of the central power. It was another thing. So the Holy Crown theory remained the official state ideology, which satisfied the nationalistic and patrimonialist noble interests, later the chauvinism and anti-Semitism too. So there is a very strong parallel thinking of patrimonialist noble interest and the county court presidents after the Second World War. And it was continuously present till the Fidesz government. Parliamentary institutions could not transcend the oligarchy of noble landowners. The close connections between nobility status and ownership and state office made professional public service illusory. So the obstacles which prevented the creation of adequate institutions of the Rechtsstaat were partly social. Landowner politicians provided too narrow a social basis for much of the liberal social ideals. Although they desired to establish civil rights, they were too afraid of social movements, the urban and the rural poor and nationalities also. So neither the professional bureaucratic rationality nor the public service with task of social integration could be strengthened. So central rationality always bumped into the local patrimonial authority, so the historical bastion of the noble resistance. So this local noble resistance is very similar than the judicial middle-level administrators in the 20th century. So some sentences about the judicial system, and this is the middle of my presentation and the detailed description of the changes of the Hungarian judicial administration. But I drop it except one idea. The one idea is coming from an excellent paper of John Ball about the path dependence or path dependent situations. He said that the established legal approaches determine the way in which new situations or new problems are handled when the cost of change is greater than the benefit of it. So I think at this point now a new path began, because the burdens of letting things happen as before became unbearable for a considerable part of the judges. According to interviews made myself, these judges feel that not only the professional values of judgeship, but their personal well-being and identity became under pressures, and something must be done. Most of these judges are relatively young, started their career years after the system change. So there's a new epoch from the perspective of generational changes. So I promise you that you can read these details about the Hungarian administration, because it's somehow half-ready articles, so the text. So you can follow the story of the changes of the administration from this institutionalized perspective. But there's a last argument about the ideas. As Dietrich Rüschmeyer argues, the use of dominant groups on some important social conditions and anticipations about future progress might have decisive effect on constitutional change. Theoretical frames, even ideas, can play as integrative force. So not only state bureaucracies, but ideas can have very important integrative social forces. They can guide the normative and institutional development if some structural factors, institutions and movements of knowledge communities help this process by protecting, conserving, nurturing concepts and ideas. There's a strong connection between the development of theory or ideas of Rechtsstaat and constitutional practice. So I must say that the jurisprudence, legal theory, legal concepts are very essential from the perspective of the fate of the institutions. So if you must learn jurisprudence, it is not because of exams and measuring studential skills, but because rule of law institutions need concepts, theories, and the most important European lesson is that without the idea of the rule of law, without the concept of the rule of law, without the theory of the Rechtsstaat in Germany, there's no development of institutional sphere. But rule of law ideas play important role even in non-rule of law contexts, and this is very interesting. In Germany, the evolution of the Rechtsstaat idea, rooted in the Enlightenment as the liberal critic of the police state, in which the political logic was a simple equating law with state order, that is the police state logic. Prussian state absolutism in Prussia, in reality, was not limited by any legal checks, but theoretical development did not have to face with structural hindrances. The ideation of progress was limitless. As a consequence, despite the conservative authoritarianism after the 1848 revolution, the theory of Robert von Mohr, who was the first big guy in the German theory of the Rechtsstaat idea, exerted considerable effects on the thinking of the emerging professional lawyers and liberal politicians also. Yeah, I just a final remark. In the Weimar era, on the basis of the constitution, a rights-based constitutionalism and the Rechtsstaat as a strong value-based concept easily got the scientific and public scenes. This conceptual development, which basically reshaped the German tradition of thinking on the power and state, gave the opportunity of surviving the normative aspect of the state even in the Nazi period. At least since the very end of the 30s, before the Second World War, the relevance of the seed of legal conceptual normativity was discovered by Ernst Fraenkel in his marvelous dual state concept. It's a very good book about the system. So, what I just must say, in Hungary, yeah, it's the last time. In Hungary, in the Hungarian jurisprudence, in the Hungarian legal theory, in the Hungarian state theory, in the Hungarian legal teaching, there was no concept of the Rechtsstaat. I just analyzed the periodicals and books after the monarchy till the Second World War, and I realized that the very notion, the concept of the Rechtsstaat is missing, which is symptomatic from the perspective of the Hungarian history. Only the historical argumentation about the traditions of the constitution, which is not a real constitutional tradition, was in the present. So there is a periodical, the title of the Rechtsstaat, is the Jogállam, the rule of law, but the articles are not about the concept of the rule of law and theory of rule of law and the Rechtsstaat, but about some practical legal problems of the practicing lawyers. So, what I, as a summary, must say here that the story of the institutions, the evolution of the institutional sphere, the evolution of the legal profession, and the evolution of the theoretical side of the legal system are very important in historical setting, and without these elements, we cannot understand the very recent crisis of the rule of law in Hungary and even in Poland. So from this perspective, Poland and Hungary are very similar cases. From my perspective, from the perspective of judicial mobility and judicial activity, the difference is striking, but probably it will shrinking in the near future.
Thank you very much.
Thank you.